A little bit about me. I'm one of the lawyers at bikeattorney.com. I've been practicing specifically cycling law since I got out of law school, so that's about 16 years now, representing cyclists in Massachusetts and some other states from time to time. Prior to that, I was a bike mechanic in Brewster at Brewster Bike for about 9 years. So I have been involved in cycling in some way or the other since I first started working. Just a disclaimer, I am not a lawyer in Rhode Island. I am only a lawyer and licensed to give you legal advice in Massachusetts. So please bear that in mind. But Rhode Island not being far away, I am familiar with some Rhode Island law. Now, what to do in an accident is really critical, because that is one of those times that most people are really not in a position to make the best decisions for themselves or to protect themselves in the long term. From 2013 to 2017, 3,958 cyclists have died across the United States. That's an average of 792 a year. And that just speaks to death from the Federal Highway Association. It does not cover injuries. 1% of all trips in the United States are done by bicycle, and those cyclists face a much higher risk of crash and injury than occupants of a motor vehicle. And the reasons are simple. When the motor vehicle, you're surrounded by 1.5 to 2 tons of metal that are designed to crumple and protect you, whereas I think we all know how vulnerable we are out on the roadway. There's nothing between us and a car or another injury. The first thing to do if you're ever involved in a crash is to protect your physical safety. I've had far too many cases where the initial impact occurs and then there's a subsequent impact from somebody being in the roadway and hit by the follow-on driver. So the physical safety is the single most important thing, because it can easily turn an injury case into something even more serious. Once your physical safety is assured, I always recommend people call the police. Despite how hostile some police departments are to cyclists, it's important to get them involved. They'll contact emergency services for you, get an ambulance to the scene, and take steps to at least do some preliminary investigation. Now, the police aren't, unless it's a really serious injury or death, aren't going to come out and take pictures. They frequently won't even take statements from witnesses who saw the crash. But what they will do is make sure that you get the information of the driver and the information on the driver's insurance, the information on the driver's car. Because that information, especially with Ubers these days, can be extremely hard to come by. I've had a sad uptick in especially during cases involving Uber, and Uber protects the information of their drivers and passengers to the point that I've had to file cases that are called John Doe cases, because I haven't been able to identify the driver or the passenger. And I'm currently fighting several cases with Uber to get them to disclose anything beyond the driver's Uber handle. So the police can help you with that. The police can help make sure that you get into the ambulance, that you're seen by EMTs, and getting that police report later is really important. They'll document everything that I'm sure you're not going to be in a position to think about. Now, immediately after a crash, I find that all my clients tell me that their number one goal is to continue doing what they were doing. If they were heading to work, if they were going home, the fight or flight adrenaline takes over at the scene after you've been injured, and everyone's first response is that they immediately want to just get home, go where they're going, and once they get home, or in some cases get to work, they routinely start to realize at that point how injured they are. We had a case in Boston a couple of years ago where the young woman sent the driver and the police away, not realizing that she in fact had a fractured wrist. She told the police, "I don't want an ambulance. I'm all set. Let the driver go. Not a big deal." And then when she got back on her bike to continue her ride home, she realized that she had a wrist fracture. In that case, because she'd sent the police away and no information was secured, and she didn't have any car insurance of her own, she wasn't in a position to recover or have anyone pay her medical bills other than health insurance. We tried very hard to get some video of the scene, but the traffic camera was insufficient to make out the plate other than a white hatchback. Now, um, if you're able, pictures from the scene can be incredibly helpful. They will allow you to establish what happened. Um, can police take your Garmin? It's an interesting question because it comes up all the time. Some people use a Garmin, some people use phones, and that's a very state-specific criminal situation. What's happening in Massachusetts right now is that they have devices that will enable them to plug into your phone and take a copy of your phone, and then they can get a warrant, but they're preserving the information. So the Garmin situation, I think, is tougher because it has a lot less personal information on it than your phone would. But I would suggest that to conduct such a search, they'd probably have to get a warrant. However, Garmin information generally is pretty helpful. The problem with GPS is that it is only accurate to about 4 feet in either direction. The goal seems to be so that it is insufficient to be used to aim missiles. So it doesn't have that level of pinpoint accuracy. And in cases, all too many cases, there are situations where a difference of 8 feet is the difference between liability and not liability. I do a lot of mapping and try to use the Garmin information as much as I can, but I frequently find that when I plot the course on Google, it'll show the cyclist riding through the bushes on the side of the road because it's not pinpoint accurate. Now, with regard to pictures, it's important in a car crash to be able to do that because it resolves issues later. I know a lot of people are riding with GoPros these days as well. Sorry. Okay. So this is a picture a client of mine took immediately after being struck on Tremont Street in Boston. And despite the fact that the driver claims she was all over the road and doing all these things operation wise, this picture alone showing the rest of the bicycle and the front wheel up against the curb, this tells the entire story of what happened. That the driver pulled into the right-hand lane where she was operating, knocked her off her bike. And not only, I always advise that people, if they can, take a picture of the license plate, if nothing else, because generally those license plates will enable you to track down the driver in the event that it turns into a bigger deal. One of the major things is when that adrenaline hits you and that fight or flight response, sometimes embarrassment is a factor as well. And the natural instinct is to get back on your bike and go home. I've had plenty of significant others take one look at somebody walk through the door and say, oh my God, what happened? We're going to the hospital right now. So it's a tough time to really try to make good choices because you just want to get to somewhere where you consider yourself safe. Now, it's especially important in situations that involve a roadway defect. The roadway defects can frequently be hidden and they can change pretty significantly over the course of their existence. So I had a case years ago where they were doing street resurfacing. And as you can see, the leaves, they dug utility trenches to either side of the road. The leaves in the fall filled that utility trench, and a cyclist going across the road went to that curb cut, and the trench is deeper than it looks in this photo. He front wheel hit that curb cut, his bike stopped dead, and he did not. He had the foresight to call a friend of his who went to the scene and took these pictures, because that's a picture of the curb, and it's only about a half an inch, 3/4 of an inch, but he was riding a road bike and perhaps most significantly not expecting it. So all of his weight was in that front wheel and he went right over. When we made a claim against the contractor, who are obligated to keep the street in a safe condition, however, what they told me and the pictures that they say were taken all have this line. The foreman testified that he paints this line on every curb cut and every driveway every day the scene closes. And this would have been incredibly difficult to be able to rebut because our client didn't see it. He didn't know paint, no paint. He was severely injured and had to be taken to the hospital by the paramedics. So in the case, the whole issue was, did they comply with the contract when they created this hidden defect? And did they mark the street? At the deposition, the foreman, who under oath testified that he paints every day without fail, was not able to explain how it could possibly be that there was a curb cut that did not have the orange spray paint warning people. Would that have been enough? I think this with the leaves makes it a very hidden, dangerous situation, because we all know a little offline as you're riding on the side of the road, it just looks like leaves on the roadway. There's not much to differentiate these trenches that are cut for utilities on the side of the road. We do far, far too many roadway defect cases, and even something as little as a metal casting set in the road can sometimes fall over or move in the roadway over time and create a ramp. And it's one of those things that if you saw it and were aware of it, you'd be able to get over it no problem. But when your front wheel unexpectedly hits a half-inch or an inch ramp, you can frequently go to the ground. And anytime you're coming into contact with the pavement, that can cause significant injury. Now, in Massachusetts, at least, you are required to file a crash report in anytime there's been personal injury or anytime there's been, sorry, just reading the question, anytime there's been property damage over $1,000 or any personal injury. Sorry, a question from Alfred. Do cyclists have the right to be anywhere on the road or just on the right side? What if one does not get hit lane when required in the interest of safety? We had a court case out in Western Mass where police were harassing a cyclist who was riding in the right-hand lane of Route 9, and he was a cycling instructor who'd come to the conclusion that the only safe way to ride a bicycle is to do so in the middle of the lane. And there's definitely arguments that the visibility to other vehicles when you're in the middle of the lane is a lot greater. But there is also a Massachusetts general law section that requires any vehicle, be it a bicycle or a driver, to facilitate passing. And in a cyclist case, if you're not over to the right, there's an argument that you're not facilitating passing. But if you have any kind of safety justification, then you are entitled to take the lane in Massachusetts. I can't speak to Rhode Island, but the reported case of Damon v. Huckowitz was the case that established that in federal court, and it looked at the balance between the requirement to maintain the requirement to allow traffic to pass you versus the safety justifications of taking a lane. I think we got into it in the hope that it would be a undisputed, you can take the lane, you're entitled to the full lane, but it turned out to be a little bit more of a mixed decision. But there's always safety justifications. Even a significant curb line can be a safety justification for staying further. What if one does not get hit by the driver's actions makes one crash? I've had this case several times where a turning cyclist or a turning motor vehicle startles the cyclist or almost comes to a crash, or evasive maneuvers result in a crash and injury with no contact with the vehicle. And that is not a problem. If somebody else's negligence causes you to be injured, the question is not, at least for the purposes of a bodily injury claim, whether there was contact with the vehicle. The question is, did their negligence cause the result, which is the injury? So absolutely no problem, because it's the same thing as a motor vehicle taking a left and somebody swerving off the road in their car and hitting a tree. The turning motor vehicle has an obligation to yield, and they had an obligation not to make that turn if it wasn't safe. Just because there was no contact doesn't mean they're not responsible for the crash. Now, when you're filing a police report, which I always recommend everyone who's injured in a crash or has any kind of significant property damage do, the important thing is to be careful. I've had a lot of clients over the years who've gotten me involved later in the case, and they'll come to me and I'll see my two least favorite words to be on a police report. Under crash description, it'll say "see attached," and then they have another couple pages of details. All it really needs to say is the bare bones of what happened. Car turned, caused a crash, impact. So that police report will actually go to the local town as well as the RMV in Massachusetts, who does crash tracking for the highway and transportation departments. And that is one of the factors that they use in determining dollar allocations and roadway structure. So if you're in a crash at an intersection and you don't file a report, there's no way for it to be recorded. We work closely with Livable Streets in Massachusetts, which is an organization specifically designed to try to multimodal transportation alternatives. And they do a lot with redesigning roadways so that they work better for everybody. They rely pretty heavily on that crash data to say, we need a protected bike lane here because 15 people have been hit or sideswiped or hit the mirror or what have you. Now, the number one thing I always tell people is get in the ambulance. People frequently don't want to. They're worried about what it's going to cost. At least in Massachusetts, there is coverage. And I'll tell you about that in a second. But seriously, don't hesitate to get in the ambulance. Don't hesitate to go to the hospital. There is, if you have health insurance, in addition, there's some coverage under motor vehicle, at least in Massachusetts, that would be available to pay for an ambulance ride. I've had people Uber from crash scenes to emergency departments, and that's never a happy situation. In Massachusetts, when you're struck by a car, there are 3 claims available. The first one is what's generally known as a property damage claim. When you're bringing these claims, though, it's important to remember that you're bringing these claims against the insurance company, not the individual. As far as negative impacts on the individual, whatever the Massachusetts Merit Rating Board's going to do depends entirely on whether it was an at-fault crash. So once the crash happens, this person's insurance rates will raise or not be raised, regardless of any steps that you may take to recover for your injury. And you're not making a claim against this person's individual assets. It's extremely challenging to do so unless an individual has very, very significant assets. And I have not yet had that situation in 16 years. But the claim is against the automotive insurance of the person who struck you. There are, in Massachusetts, 3 claims. The first one's property damage. I go through property damage first because it's the easiest one to understand. Your bicycle's damaged, your clothes are damaged, maybe a cell phone. You can recover the value of that property. Bear in mind, helmet warranties require that they be replaced every so often. They vary from 1 year to 3 years, but helmets do degrade over time. In addition, they are one impact items. So once you've had an impact with the pavement or a car, that helmet's warranty is void. It will not protect you. The structure of that helmet is damaged and it must be replaced. The other claims you have in Massachusetts, they have a setup called personal injury protection, also called no-fault insurance. It does not matter who was at fault for the crash under personal injury protection, also called PIP. Now, in Rhode Island, Personal injury protection is mandatory in Massachusetts. Every insurance policy in Massachusetts has it. It is frequently available from out-of-state drivers who are operated in Massachusetts because out-of-state policies have a mandatory coverage provision that says if that insurance is required in the state that you're operating in, that your insurance will cover it. So if the crash just happens in Massachusetts, even if the person's from a state, if they have an auto insurance policy, you can generally get them to provide you with PIP benefits. PIP is the primary insurance for anyone injured in a motor vehicle crash. It is a multi-tiered system that is really complicated, but essentially it's $2,000 of coverage if you have health insurance and $8,000 of coverage if you do not have health insurance. It will cover your medical bills. It will cover lost wages, though it'll just cover actually lost wages. If sick, vacation time, things of that nature are not recoverable against PIP, they are recoverable against a bodily injury claim generally, but PIP's designed as a Band-Aid. PIP was designed so that when someone injured in a motor vehicle crash shows up at a hospital, they don't say, oh, do you have health insurance? Because otherwise you're going to have to go it yourself. So it initially provides a pool of coverage available for medical bills, available for lost wages. It'll also cover what's generally referred to as loss of use or replacement services. So it will cover Uber rides to work and back because you're injured and can't ride. It will cover lawn mowing because you're injured and couldn't mow your lawn and had to hire somebody to do it. I had them cover boat wrapping once because my client would have wrapped his own boat and was not able to as a result of the injuries. And so PIP was available to cover. Once that initial $2,000 is exhausted, your health insurance moves to the primary insurance on the case. PIP then moves to secondary for an additional $6,000 of coverage. It's available to help with copays from your health insurance. If there's a deductible from your health insurance, that can be billed off to PIP. The most common problem that sends people to me is that they were injured a couple months ago, they've treated for a while. Your health insurance will eventually figure out you're treating because of a motor vehicle crash, and they will want to see evidence that that PIP is exhausted because they know it's available to every driver in Massachusetts. And they know that that's a pool of coverage that they're never going to have to pay. Now, with PIP, there are a couple situations where it's a $8,000 pool instead of a two-tiered $2,000 and $8,000 pool. That's if you are on Medicare or Mass Health, or if you have what's referred to as an ERISA health plan. That has to do with the way the health plan is funded. In Rhode Island, it is possible to have PIP, but unlike Massachusetts, where every motor vehicle insurance policy includes PIP, in Rhode Island, there is a variety of options that one can pick when signing up for insurance. They include PIP, though I'm told that's quite infrequent. They also include what's referred to as MedPay. MedPay is an additional pool of coverage that just covers medical bills. It is a little easier to deal with, and tends to be a straight pool of $5,000. Now, both PIP and MedPay, if you're in a car-on-car situation, are paid by the driver's auto insurance. For a cyclist, as for a pedestrian, the PIP comes from the insurance of the person who struck you because you don't have to have auto insurance in order to legally operate a vehicle. In order to apply for this no-fault coverage, there's an application process, and you have to submit medical bills or receipts or what have you to the insurance company adjuster that they've assigned to the PIP claim. A couple caveats. You can definitely be hit by somebody in Massachusetts who does not have car insurance. New Hampshire is just across the border. They don't require car insurance. There is still coverage available. You can get coverage for PIP against your own auto insurance if you have an auto insurance that includes PIP or MedPay. You can also, in the event that you don't have auto insurance and are struck by an uninsured driver, there is a organization in Massachusetts that all the insurance companies fund to provide PIP benefits in completely uninsured situations. That's why I always say get in the ambulance, because there's coverage available for it, and you should just do it. Too many people leave the scene with significant injuries, and when they don't have to. And the number one reason people don't get in the ambulance is because I'm concerned about the cost. Now, the third claim is what's referred to as a bodily injury claim. That is what people think of generally when they're talking about a claim against an insurance company. It contemplates pain and suffering. It contemplates the portion of your medical bills that aren't paid by PIP. It contemplates lost wages that weren't paid by PIP, and the cost, delay, inconvenience to you of having been injured by a motor vehicle. In Massachusetts, there's a minimum auto insurance policy limit of $20,000. That is not a lot of money, given how severely we can get injured by a car. But if you have a financed or leased vehicle, that vehicle finance arrangement is going to require that it has at least $250,000 of insurance. And one of the first things that your lawyer will do, or you can find out yourself if you write and specifically request it, is to get the policy limit of the person who struck you, because that will definitely dictate your best course of action. Dealing with a claim where there's a severe injury and only $20,000 available is a lot different than dealing with a claim with severe injuries and hundreds of thousands of dollars of insurance. A couple things to be aware of, though. Your health insurance has what they call a subrogation claim for any medical expenses they extended on your behalf as a result of the crash. They only recover in the event that you recover. So if you're not making a claim, you have no obligation to pay your health insurance. Or if you decide to not make a claim, if you lose your claim at trial, the health insurance recovers nothing. But they file these liens both with the lawyers and the auto insurance companies to make sure that if there's a payment made to an individual, that that individual satisfies the subrogation claim. The health insurance company will seek recovery of any medical bills that are extended on your behalf, though it only seeks recovery of the actual amount of money that they paid, not the full amount of the medical bill, which is a built-in discount because health insurance companies pay contract rates, not the full billed amount. In addition, you should be aware that there is a variety of situations where your own auto insurance will provide some coverage. If you're struck by an uninsured motor vehicle, you could potentially get no fault or PIP from your insurance. You could potentially get MedPay if you have MedPay. But the most common situation is that an individual is struck by somebody who has only limited insurance or the minimum $20,000 policy limit. If your policy limit for bodily injury is higher than that of the person who struck you, you can recover the difference in the event that you were injured sufficiently that your claim is worth the amount of money. So for example, if you're struck by if you're doored by a cab, which happens all the time in Boston, cab companies are very cost conscious, especially these days, and they always carry the least insurance that they can get away with. So they typically have $20,000 policy limits, but as we all know, getting knocked off your bike by a passenger exiting the door can easily lead to fractures and a variety of serious medical problems. If such a situation occurs and you have a $100,000 or $250,000 underinsurance available to you from your auto, you can recover the $20,000 from the cab company as well as an additional $80,000 from your own auto insurance. One of the takeaways that my clients have given me over the years, after listening to my hour-and-a-half long intake speech when I explained everything in great detail, is that they frequently will go check their auto insurance, and a fair number of them raise their limits right away because they weren't aware that their own auto insurance would provide coverage that would provide a safety net in the event that you're hit by someone with no insurance or who has limited insurance. Um, the one of the bigger questions that I get from people all the time is, can you do this without a lawyer? I routinely, because you can frequently have a situation where you have minor injuries, scrapes, but you have property damage. The insurance companies love to play games with property damage. They are hostile to paying for your bicycle. They're hostile to paying for the helmet because the insurance companies look at it as what they call a sum certain claim. So if your claim's for $1,000 and they can pay you $900 on it, that is the insurance adjuster justifying their existence to their company and saving themselves $1,000 or $100. I do try to help people self-help them through property damage claims because it is not financially viable for me to bring a suit every time there's a $300 property damage claim. And I also didn't become a lawyer so that I could take a percentage of your bicycle for representing you. So I encourage people to file property damage only claims with the insurance. But I always encourage them to do that just in writing, because if you call those adjusters, every line in and out of an insurance company is recorded, and they will immediately start to segue into, well, can you tell me how it happened? How fast was you going? How fast was this going? Give me a bunch of details about the crash so that they can try to set up some kind of liability defense. Now, Massachusetts and Rhode Island differ a little bit in the percentage that you can recover in the event that you are any percentage negligent. In Massachusetts, we're what's called a comparative negligence state, so that in order to recover anything from the person who struck you, a jury would have to find that they are at least 50% negligent for the crash. My research over the course of this week has determined that Rhode Island's not, and that Rhode Island takes a different approach where you can be awarded your damages even if the other person's some percentage of negligence. If they're 10% negligence and you're negligent and your case is worth $100,000, the judge would reduce that jury award to just $10,000. Whereas in Massachusetts, if the cyclist is found to be 50% or more negligence, they will recover nothing. Now, most of our claims do end in a negotiated resolution. They don't always end prior to filing suit. About 50% of our claims we're not able to resolve prior to suit. And we have to file a lawsuit in order to make recovery. But trials are increasingly rare, not just today because courts aren't doing trials till September, but even before that. 99% of civil cases resolve short of trial. And I tend to only have a couple trials a year, 4 or 5. Most of the several hundred cases I deal with a year do resolve by resolution. Now, I think you can definitely deal with a PIP or a MedPay claim. It's just a little technical on the exactly what you need to submit at what situation. I think when you're dealing with a bodily injury claim, that can be a lot more challenging because they want to take statements. I have personal injury protection in Massachusetts entitles the insurance company to take a statement from the injured party. And in my office, I spend a lot of time working with people so that they don't say something unintentionally during the course of a statement that prejudices their case later, because the insurance companies spend a lot of time playing with time, distance, and speed in an effort to try to put some negligence on the cyclist. And there's always a point where if you're fast enough but far enough away from a door that opens in your path, at some point it becomes the cyclist's fault. If the door opens into you, that's absolutely the driver's fault. If the door opens ahead of you, just ahead of you, and you come into contact with that door, that's absolutely the driver's fault. If you were 100 yards away and the door opened and you saw it, but you hit it anyway, that makes the fault situation much more complicated. I think the property damage and PIP or MedPay can be done by individuals. I think bodily injury cases are a real challenge. So I always advise that everyone retain a lawyer or at least seek counsel from a lawyer. I think one of the things that I've learned over the years is that being a cyclist myself and a member of the community, I am willing to give away a lot of free advice because I'd much rather help you than take a case that I don't think is going to be profitable. Because I'd rather self-help you through a couple letters to the insurance company or a small claims action. When it comes to bodily injury, you have to, in order to bring a bodily injury claim, you have to have over $2,000 in medical bills, or a fracture, or permanent scarring, or a death. So there are limits to bringing a bodily injury claim in Massachusetts. That varies pretty wildly by state. The limit in New York, for example, is much, much higher, so that you can't bring a bodily injury claim unless you have, don't quote me on it, but I think it's about $50,000 in medical bills, which is a lot. $2,000 is not a very high threshold. In Massachusetts, that is less than an ambulance typically costs to take you to the emergency room. So I appreciate you having me here today. If anyone has any questions, I'm happy to field some questions for you, but it's been a pleasure. I'm always available at bikeattorney.com. Anytime you need anything, I'm happy to help. Does anyone have any questions?
Anybody have any questions?
People are muted. So.
Yeah, well, people can unmute themselves, and it's a good opportunity to ask any questions of things that you might have been thinking about in terms of riding and perhaps getting into an accident. So it sounds like that the majority of the time the burden is on the cyclist to make sure that they have, am I interpreting that right?
The burden's on the cyclist to make sure they have what?
The photos and all of the...
Well, the burden's on the person bringing the claim, whether it's a cyclist. I mean, most of this applies to motor vehicles too. If you're bringing a claim, you have the burden to prove that claim.
Right.
So juries frequently struggle with the he said, she said situation, where, for example, I have a mediation tomorrow in a case where the cyclist says that the motorist ran the stop sign. The motorist says they stopped at the stop sign. So that's a tough one to prove without a witness who has nothing to do with it saying, no, I saw the whole thing and they ran the stop sign or didn't run the stop sign. Now, on the bright side, you have motorists have an obligation to come to a stop at a stop sign and then yield to traffic in the intersection or so close thereto to prevent a hazard. So that's not a situation where whether she stopped for a second or rolled through or even came to a full stop is the important thing. But as the person bringing the claim, legally in all states, you have the burden to prove that claim. And if you don't prove that claim, you get nothing, at least at trial.
Somebody asked, what about go ahead.
The date stamps on cameras. You know, the date stamps on cameras are a problem because I have a couple cameras, and one of my older cameras allows me to set the date stamp every time I put in new batteries. So they're not necessarily accurate. However, it is easy to establish what they call the authenticity of those images, because all you need is the person who took them to say, yes, I took them. They're true and accurate representations of what they show. I took them on whatever date. And that's the kind of thing that's incredibly hard to rebut, because you'd have to have somebody saying, well, I saw the cyclist the whole time at the scene and they didn't take any pictures. That would be a tough one, but you would be able to get those pictures into evidence as just with the cyclist indicating that, yes, I took these pictures. Yes, they're true and accurate. Common bike behaviors that lead to findings that the cyclist was at fault. The problem with jury trials for cyclists is that when you pick 12 jurors, you're going to get 12 drivers, for the most part, at least in Massachusetts. And so there is definitely a prejudice against cyclists on the part of juries. Juries who are drivers and not cyclists are anxious to find that the driver did nothing wrong, that the cyclist wasn't paying attention, that the cyclist was doing something reckless. I find that's not the case, because I think we're all quite aware of how vulnerable we are when a 2-ton machine is going by us at 30, 40 miles an hour. That's not the kind of situation that leads to a real amount of reckless behavior, though I see the occasional courier going the wrong way down a one-way street, things like that. But it can be a challenge. The burden on cyclists regarding high-vis closed lights or other ways to make us more visible. Massachusetts law requires that a cyclist have a front and rear light an hour before sunset to an hour after sunset. High-vis clothing is not required by any Massachusetts statute. However, I will absolutely say I recommend high-vis clothing. I recommend lights. I recommend using those lights all the time, because the number one thing that causes cycling crashes is driver inattention. I think as drivers, you're always on the lookout for cars. And most drivers, I think, are on the lookout for pedestrians. I think the cyclists don't fall into that category one way or the other. So I frequently do depositions with drivers who didn't see the cyclist ahead of them on the right side of the road until the impact. And they are as shocked as anyone else to hear that, you know, there was something there. I think driver education's come a long way. The driver's license test in Massachusetts used to have 0 questions about cyclists. Now there's an entire chapter in the book. And I think that's really the first opportunity to get to kids who are just starting to drive and kind of making them a little more sensitive to that. What's also helped in Massachusetts and is moving Boston up in the safe cities for cycling are facilities. Painted bike lanes. I'm sure you've all seen it's not a bike lane, but there is a bike logo in the street. That's not to say that street is only for use by cyclists or something. It's just to give drivers a visual indication that cyclists are going to be using the street and to prompt them to take a good look as they're going along. But Boston's starting to put in protected bike lanes, which are really great for everything but passenger doorings. I've yet to have a passenger dooring of somebody in a protected bike lane where the parking's on the outside. But I saw an overhead picture of a roadway in Germany. And apparently in Germany, it is much more common to park your cars in the middle of the road. So you have 2 lanes of cars, then traffic lanes, and then bike lanes. That removes a lot of the interaction between motor vehicles and cyclists. The most common types of crashes that we see are doorings, which account for about 1/3 of all the cases that I do, right hooks and left hooks. So when the motor vehicle pulls in front of you, but not far enough and takes a right-hand turn, I think juries especially struggle with the idea that on a 1-lane road, when a cyclist is traveling to the right, they have the right of way. And I encourage people and juries and adjusters to think about it as if it was 2 cars. Because if it was 2 cars and that car takes a right-hand turn and hits that car, nobody's going to argue that it's not that car's fault. And it doesn't change just because it's a cyclist. But I think juries it takes some work to get a jury of non-cyclists on the cyclist side, because I think amongst drivers who've never been on a bicycle or bike on the bike paths, they are kind of the opinion that cycling on the roadway at baseline is not a safe thing to do. And so you've got to overcome that hurdle a lot with adjusters too, because insurance adjusters do 99% motor vehicle crashes. So I spend a lot of time educating juries and adjusters about cycling law and about the experience of a cyclist to make sure that they have a good sense that you can do everything safely and still get into a crash that's completely somebody else's fault. The insurance companies make a lot of hay about The cyclist was traveling too fast, but it is the rare roadway that a cyclist can exceed the speed limit. Um, though road speed limits are going down, I've only had a couple of cases where the cyclist was genuinely going too fast, though there is always too fast for road conditions. And I think what you get from non-cyclists is the idea that traveling on the roadway is dangerous and therefore negligent at baseline. So what the driver has to have done has to have been really, really bad, not just an error or a miscalculation. Um, and I've had a couple of jury verdicts over the past couple of years where they came back for the driver finding no negligence, even though the driver was cited at the scene and took a right-hand turn across the path of. The last one really hurt because 6 people on the jury self-identified as cyclists. And yet they were completely unsympathetic to the cyclist in the bike lane who was struck by a motor vehicle from behind by a car pulling into the parking lane. So I definitely see some prejudice, and it's just based on the idea that cycling on the roadway is not safe. And therefore, even doing that is baseline negligence for the cyclist. And that's one of the major issues that we're fighting against. My firm spends a lot of time. We were involved in the passage of the Cyclist Bill of Rights and Responsibilities about 7 years ago, which made a lot of changes to Massachusetts law in favor of cyclists. It put the first Doring statute on the books. Prior to that, there was no statute that spoke in terms of the Doring. And it inserted including bicycles or including cyclists into a number of sections on Mass General Law, just to make clear that you can't take a left-hand turn in front of any vehicle on the roadway if it's not safe to do so. It also, for the first time, put a right hook specifically addressing cyclists on the books. It says that if you take a right-hand turn across the path of a cyclist who you've passed, that you're at fault for the crash. And that, I think, has gone a long way to letting us argue that it is that driver's fault. Do I have comments on group rides and associated accidents? I do. Group rides are a challenge because we all know how hostile some drivers can be. And honestly, the group rides are a bigger target. I had a case a couple of years ago where a left-turning driver took out the 4th and 5th member of a line of 10 cyclists. And he said, well, I didn't see any cyclists. And I'm like, there's 10 cyclists on the roadway. How could you not? But it turns out the sun was in his eyes. And he was just, I don't know, hoping for the best and taking a left. 3 or 4 cyclists managed to avoid injury by scattering, but he did manage to clip 2. So ride leaders are key for group rides because they are the ones who really have the best opportunity to look out for that driver who's not paying a lot of attention. Sadly, there are no lights on a car that say the driver is looking at their phone or not paying careful attention. There was a demo of a autonomous vehicle that had eyes on the front for pedestrians and cyclists. And so the pupils would move to show the pedestrian that the car that saw them and that it was safe to continue. I don't think that one's going to catch on because people found it creepy. And when the car pulled up to the stop line and was looking at them, nobody was willing to step in front of that car because you have an autonomous vehicle like looking at you with its pupils. But it was an attempt to try to make the car say, I see you. And visibility is really the important thing. So that's why the high vis works so well, because that is a color that can be seen. The orange and the yellow can be seen from a long way away. They pick up the light. There are paints out there that reflect off headlights, but only off headlights. And they make a lot of cycling clothing that in daylight would look black, but at night has all kinds of reflective piping on it. And that's designed to catch the attention of the inattentive driver. I mean, nothing's going to make people put the cell phone down 100% of the time. Even though we just passed a hands-free law in Massachusetts, I still have a lot of crashes And the statistics bear that out. Since the iPhone was released, the number of motor vehicle crashes has really, I think it tripled the first year the iPhone came out.
Wow.
And I don't think people are getting any better at it. And the question for me is, now that infotainment systems are getting so complicated in cars, that's another distraction deficit that we're dealing with. And it's impossible to say that the driver was looking at their GPS for the next direction because it's just not recorded where the driver was looking. Though technology is coming to help in a variety of ways, self-driving cars are really struggling with cyclists. They don't quite know what to make of cyclists right now. The algorithms are struggling to try to predict what's a safe way to pass the cyclists. But vehicles that auto-stop, a variety of vehicles have automatic brake application, and a variety of vehicles have video that is taken automatically in the event of a crash. So I'm hopeful. I mean, it is getting safer on aggregate for cyclists. I think I'm seeing that offset by the fact that more people are cycling. And given the fact that bike shops across the country are sold out of bicycles right now, and nobody really wants to be on a bus given the COVID situation, I think we're going to see cycling really explode, because nobody wants to be on the MBTA, on the bus, on the train, in close proximity with people, whereas just being on a bicycle is social distancing, because unless you're drafting, nobody's going to get that close to you. So yeah, unless anybody else has any questions.
I have one last question, Andrew.
Yes,
it's
ma'am.
about, so you mentioned it briefly with those photos about the curb cutout. So what happens if you are in an accident, it's not another driver, but it's actually a defect in the road? Like is it the same sort of steps you're following?
No, because Massachusetts law only allows you to recover $5,000 from the municipality that is in charge of the defect. So, for example, a pothole in the city of Boston, there's a cap on that claim. There's also notice requirements that you have to give notice to the city within 30 days. And the $5,000 cap, as well as the aggressive legal departments by cities, tend to really make those non-viable cases. The trick is to find the contractor. In that case, they were doing roadwork resurfacing, so that contractor was relatively easy to find. It can be a little more challenging in the situation of something that's not just wear and tear. You got to look back at the paving company. We get a lot of problems with castings, which are the metal structures in the roadway that hold up manhole and utility covers and grates. We were involved in a case many years ago that the Massachusetts Highway Department changed their regulations so that the slats on the grates have to be across the wheel, not wheel trappers. But the goal is to find out who put that grate in last, because they put it in wrong and they didn't do it right, or who paved that roadway such that the casting became loose and started to dip in the roadway and create the ramp. Or we had a case not long ago where a drainage casting depressed in the roadway, but because it was all black asphalt around it, it was almost impossible to see from the angle that our cyclist was going. It wasn't until you came the contrary angle that you could see that that was a 6 to 8 inch dip in the roadway, but that pavement camouflaged it. But we can find the contractors as long as they paved it within 10 years. There's a statute of repose in Massachusetts, which puts a 10-year deadline on that, but that information is generally available for the municipality. I think the potholes is a much tougher one because the law protects the municipality from any claims over $5,000.
That's really interesting.
Well, I hope so. I think it is.
Yeah.
Well, it's been a pleasure. I appreciate you having me.
Yeah,
I'm
absolutely.
told my partner is going to get you some other speakers.
Yes, yes. We're gonna,
So
next week we're gonna have a chef who actually a personal chef. She cooks for some of the New England Patriots and other New England sports teams, that she's gonna show us how to make some energy drinks that are more natural and snacks.
Snacks for riding.
Andrew, you're invited.
Yeah, feel free to join.
Send me the link.
I'll send you the link. And we have, I think the rails to trails, and then maybe someone from lab. So
yeah,
some
Excellent.
good speakers coming up. So
Yeah.
thank you so much.
Thanks very much. And seriously, anyone, if you have any questions, feel free to contact me. I'm happy to help.
And I'll send out your contact info too.
That'd be great. I'd really
Thanks,
appreciate
Andrew.
it. Have a
Okay.
great day.
You too.
Appreciate
Take
it.
care. Bye-bye.
Bye-bye.